not some book, not the lawyers. In the name of God, do your duty.
Americans are fascinated with the legal system in the United States. Movies and television capture the public's interest in how our legal system operates. But most people tend to overlook the most important element of our legal system, the jury. The 12 citizens chosen from the community who will ultimately determine the outcome of these cases.
You're talking about a matter of seconds. Nobody can be that accurate.
Well, I think testimony that could put a boy into the electric chair should be that accurate.
Have you reached a verdict?
We have, Your Honor. Your Honor, we've agreed.
Guilty. Guilty. Not guilty.
Who are the people who make up our juries? And how did the jury trial become such an important element in our system of justice? The concept of jury trials dates as far back as 400 BC in ancient Greece. Since then, Western civilization has seen the jury system come and go. During the reign of the Roman Empire, imperial magistrates determined the guilt or innocence of an accused in criminal cases and could impose penalties based on social rank. While a privileged Roman citizen would be fined for an offense, those less fortunate might be thrown to the beasts. The Spanish Inquisition saw a system of justice based on allegiance to the church. Instead of a trial by jury, torture and execution awaited those who were accused of heresy but refused to confess their crime. In medieval England, the king and his lords held absolute power. Justice was often decided by declaration of the king or by physical combat.
The Queen is innocent! She has got a wart.
Many times, guilt or innocence was determined without a jury, usually by methods that defied logic and fairness.
If she weighs the same as a duck, she's made of wood.
And therefore...
A witch! A witch!
In the year 1215, English citizens forced King John to sign the Magna Carta, a document that guaranteed the citizens their right to trial by their peers, making the jury trial a permanent right under English law. The jury system came to America along with the first colonists in the 1600s. But by the late 1700s, the British government was denying the colonists the right to trials by jury. Without this right, the British colonial courts had become merely an instrument of the king to deprive the colonists of their liberties. In 1776, Thomas Jefferson listed the denial of the right to trial by jury as an important reason for the Declaration of Independence. The respective colonies are entitled to the common law of England, and more especially to the great and inestimable privilege of being tried by their peers of the community according to the course of law. American colonists later fought and died for their independence and for the right to trial by jury, which would become one of the cornerstones of our system of justice as we know it today. After the Americans gained their independence from England, the Founding Fathers guaranteed the right to trial by jury in the Constitution and the Bill of Rights. As the nation grew westward, this new American system of justice followed. In these western territories, where the law was once laid down by the gun and the sheriff's posse, the principles of American law and the jury trial eventually found their way into the frontier. Americans began to appreciate their rights under a system of justice based upon trial by jury. In fact, when Texas declared its independence from Mexico in 1836, one of the reasons listed for independence was that Mexico had failed to protect Texans' rights to jury trials. And when Texas joined the Union of the United States in 1845, the Texas Constitution expressly stated that the citizens' right to trial by jury in both civil and criminal cases would never be violated. That is still true today.
All rise. Local Court of Texas is now in session.
So how do citizens exercise their right to sit on a jury? Who are the 12 people who make up a jury? And how are they selected? Join us now in a hands-on adventure that invites you to explore the answers to these questions by participating in the jury process. Today, you become a juror. You take an oath. You participate in a mock trial, and in so doing, become better prepared to fulfill one of the most treasured responsibilities of the American system. And finally, you reach a verdict, announced in a phrase as time-honored and powerful as it is simple. We, the jury. The Texas Young Lawyers Association is proud to present We, the Jury.
If you are 18 years old and have a valid driver's license, you're eligible to participate in one of the most prestigious and time-honored traditions of the American justice system, the jury trial. Throughout your life, you may be called upon to serve on a jury in your community. And whether it's a famous case that makes headlines or a case that few people outside the courtroom know anything about, you'll have the solemn duty and responsibility to decide the outcome of an important case. Serving on a jury is not a privilege, but an exciting opportunity to participate directly in our system of government. It also ensures that our valued right to trial by jury, guaranteed by the United States Constitution, is forever preserved. Juries have been an important part of our legal system from the beginning. As you will learn, jury verdicts have had a profound impact on our society. But no matter what the case is about or how much or little attention a case gets, the jury verdict is of vital importance to the people involved. In short, jury service is an awesome responsibility of citizenship. In We the Jury, the American Bar Association Young Lawyers Division will help you prepare for jury service by allowing you to first see what it's like to serve on a jury. You'll be selected as a juror. You'll observe a trial from beginning to end. You'll listen to the evidence from witnesses. You'll deliberate with fellow jurors. And at the end, you'll hopefully reach a verdict that will determine the fate of another human being. On behalf of the Young Lawyers Division, I invite you to experience the jury process. Enjoy it as you learn from it. And when you someday are called for jury service, answer the call. At the end of trial, when you rise to say, "We the jury," you will have done your part to ensure that we remain a government of the people, by the people, and for the people.
All rise. The local court of Texas is now in session. Honorable Judge Lawrence Law presiding.
Thank you. Please be seated. Will the jurors remain standing? We're here today for the case of Patty Payne versus Diane Davis. I'd like to begin by first saying thanks to each juror for fulfilling your civic duty by serving on this jury. It is your service here today that makes the American legal system the best in the world. I will now swear you in. Will each member of the jury please raise your right hand? Do you swear or affirm that you will render a true verdict according to the law as given you by this court and the evidence submitted according to the rulings of this court, so help you God? I do. Please be seated. We will now begin with opening statements. Plaintiff's counsel may proceed.
Thank you, Your Honor. Members of the jury, this case is about distractions. Diane Davis became distracted while she was driving one day in June of last year. And as a result of her distraction, Patty Payne suffered harm. I represent Ms. Payne, and we're here today to make things right for her. Now, as in every case, the plaintiff, that is the person who brings the lawsuit, has the burden of proof. We must prove to you the facts as we see them by a preponderance of the evidence. Now, all that fancy legal term means is that we must prove to you that it is more likely than not that Miss Davis was negligent. That is, she failed to exercise reasonable care. And that as a result of that negligence, my client, Miss Payne, suffered damages. Now let's talk about the facts. One Sunday morning in June of last year, Miss Payne was driving to work. And she came to the intersection right out here at Main Street and Avenue A. And she came to a red light and she stopped. And while she was waiting for that light to change, Miss Davis slammed her car into the rear of Miss Payne's car. That impact was so forceful that it knocked Miss Payne's car all the way into the middle of that intersection. Now you're going to hear today that Miss Davis was rushing to get to work because she was late. And you're also going to hear that she was on her cellular phone when that accident happened. In short, Miss Davis was distracted. And this accident, the reason why we're all here today, is her fault. Now, immediately upon the crash, Miss Payne felt a horrible pain to the back of her neck. Thinking perhaps it's just soreness and bruising, she decided to tough it out. She endured that pain for 5 whole days before she couldn't take it any longer, and she finally went to go see her family doctor. It's that doctor who referred her to an orthopedic surgeon whose name is Dr. Sarah Femer. You're going to meet Dr. Femer today. And Dr. Femer is going to testify that Miss Payne suffered severe and permanent injuries as a result of that accident. And Dr. Femer is also going to testify that Miss Payne requires surgery, and that even after this surgery, Miss Payne will continue to suffer from permanent effects of that injury. Additionally, Miss Payne's automobile was damaged. Now, she has estimates that will establish the cost to repair that automobile. You, the jury, will have the opportunity to decide what is fair and just compensation for Miss Payne's damages. And we believe that after you hear all the evidence today, you are going to agree with us that Miss Davis should compensate Miss Payne for her damages, because Miss Davis was at fault for that accident. Thank you.
Defense counsel.
Thank you, Your Honor. May it please the court. Ladies and gentlemen of the jury, this case is really about who you can believe. Patty Payne or my client, Diane Davis. It is true, my client was on her way to work that day. She was a little late. She was on her phone. However, she wasn't distracted, and she remembers everything that happened. She came to the same intersection as Ms. Payne. However, when she got to the intersection, she stopped behind Ms. Payne's car at the red light. She didn't move until the light turned green. However, when the light turned green, Ms. Payne started to move, but then for no apparent reason, she stopped. My client, Ms. Davis, slammed on her brakes in an attempt to avoid the accident, but it was too late, she was too close, and her car collided with Ms. Payne's. You will hear from an eyewitness today, Mr. John Smith. Mr. Smith was coming out of the donut shop, which is at the corner of the 2 streets where the accident occurred. Mr. Smith will tell you he saw the accident and that the light was green when the accident occurred, just as Ms. Davis remembers. So yes, there was an accident. An accident. However, the accident was Ms. Payne's fault, not Ms. Davis's. The plaintiff, Ms. Payne, gets to go first today Ms. Davis simply asks that you wait till you hear all the evidence before coming to a decision. We believe once you hear all the evidence, common sense will dictate that the accident was Ms. Payne's fault, and Ms. Davis doesn't owe her a dime. Thank you.
The plaintiff may call her first witness.
Thank you, Your Honor. We call Patty Payne. And would you please introduce yourself to the jury?
Yes, my name is Patty Payne. I live here in town. I'm married to Paul Payne. We have 3 kids. I'm a waitress at Ray's Cafe down the street.
Miss Payne, were you involved in an automobile accident on June 27th of last year?
Yes, I was.
Would you be kind enough to explain to the jury how that accident occurred?
Well, it was a Sunday morning at about 9:30. I was driving to work on Main Street, and I had stopped at the red light at the intersection of Avenue A. And all of a sudden, somebody slammed into my car from behind, and it turned out to be Ms. Davis. She hit me so hard that she knocked my car out into the middle of the intersection.
Miss Payne, were you hurt in the accident?
Yes, I was. When she hit me, my head whipped back, and I heard this loud pop in my neck. I felt this shooting pain at the base of my head down into my neck.
And what did you do after Miss Davis ran into you?
Well, I was stunned. All I could think about was the burning pain in my neck. I started crying, and I guess I put my car into park and turned the car off.
And then did you get out of the car?
At first, I couldn't. After a while, though, I was able to calm down a little and get out of my car.
And did you talk to Diane Davis at the scene of the accident?
Yes, I did. After I was able to get out of my car, she came up to my door.
And what did Miss Davis tell you?
Objection, Your Honor. Calls for hearsay.
Your Honor, it's an admission by the defendant.
Objection overruled. I'll allow it. Go ahead, Miss Payne.
She said she was sorry and that she just wasn't paying attention.
Now, did anyone call the police at that point in time?
Well, no, we exchanged information, but then we both just left. I didn't call the police because Miss Davis said that it was her fault, and she would cover all the property damage and any medical bills I had.
Objection, Your Honor, a move to strike. That last bit was argumentative, non-responsive, and prejudicial, not to mention hearsay. Counsel only asked her if she called the police.
Your Honor.
Counsel's right. The jury will disregard Miss Payne's last statement, except as to the fact that she didn't call the police.
Miss Payne, was your automobile damaged because of this accident?
Oh, yes, it was. The rear bumper was severely damaged.
And have you gotten your car repaired?
Oh, no, not yet. I can't afford it. The repair shop told me it would cost $1,800 to repair.
Your Honor, I believe that the defense stipulates that the estimated cost of repairs to Miss Payne's automobile is $1,800.
Yes, Your Honor. We stipulate to that.
The court will deem the matter stipulated. The jury will take as a fact that it will cost $1,800 for Miss Payne to repair the damage to her car.
Miss Payne, I am now going to show you what has been pre-marked as Plaintiff's Exhibit Number 1. Your Honor, the defense has stipulated as to the admissibility of this exhibit.
It's admitted.
May I approach, Your Honor?
Yes.
Thank you. Now, Miss Payne, would you please describe Exhibit Number 1 to the jury?
It is a picture of my car that I took on the afternoon of the accident. You can see how the rear end of my car is just destroyed.
And what kind of car is that, ma'am?
It's a Peugeot.
Now, Patty, did you get medical help for your injuries?
Yes, I did. I saw my family doctor, who referred me to a specialist, Dr. Sarah Femer, and I saw her within a couple of weeks of the accident.
Do you have any idea how much your medical bills are?
Yes, sir, I do. My medical bills are $15,000 so far, and I understand they could go as high as $50,000 if I have surgery.
Do you still feel any pain today from the injuries you received in the accident with Miss Davis?
Yes, sir, I do. I've still got this sharp pain in my neck.
And how else have the injuries affected your life?
I can't do many of the things I used to do. I can't sleep. It hurts to work. I'm in a bad mood all the time. I'm worried that I'll never get to feeling better, and it's just changed me completely.
Thank you, Ms. Payne. Your Honor, I have no further questions at this time. I pass the witness.
You may cross-examine the witness.
Thank you, Your Honor. Miss Payne, when did you say you started to feel pain?
Right when the wreck happened.
Ma'am, you had a mobile phone with you at the time of the accident, didn't you?
Yes, I did.
And even though you were in the severe constant pain that you testified about, you didn't call the ambulance on your phone, did you?
No.
In fact, you didn't call anybody at the time of the accident, did you?
I was too shocked to do anything. I did call my husband as soon as I got to work.
You went straight to work, though, right?
Yes, I had to be there at 10 for the breakfast shift. It's usually pretty busy.
You didn't stop by the emergency room on the way, did you?
No, I didn't.
And you didn't go to your family doctor the next day?
Well, no, not for a few days. I kept hoping that I would feel better.
In fact, you saw your family doctor for the first time 5 days later.
Right. My neck just kept getting worse and worse.
You said you did go immediately to work after the accident. Did you tell anyone that you had been hurt in an accident?
No. They don't need to hear my problems.
As a waitress, Miss Payne, isn't it true that you lift heavy trays over your head?
Yes, I suppose so.
Do you do that many times a day?
It's part of the job, I guess.
And you lift full pitchers of water and tea?
Yes, ma'am, those two.
And that makes you pretty sore by the end of the day, doesn't it?
Sometimes.
In fact, you're sore most of the time, aren't you?
Yes, but I never hurt as much as I did after your client hit me.
Miss Payne, just try to answer the question she asked.
Yes, Judge, I'm sorry.
And how long have you been a waitress, ma'am?
About 6 years, I think.
When you saw Dr. Femer, did you tell her about the heavy lifting you do in your job?
No, well, I wasn't there about my job. I was there about the car wreck. I put down that I'm a waitress on the form that I filled out in the lobby of Dr. Femer's office.
I guess my question is, ma'am, did you talk about anything other than the car accident when you went to see Dr. Femer?
No, I don't think so.
Ma'am, you didn't see Ms. Davis coming up behind you before the accident, did you?
No, I guess I was just looking straight ahead.
So you wouldn't know if she was stopped right behind you before the accident, would you?
I didn't see her before I felt the impact, no.
No further questions, Your Honor.
The plaintiff may call her next witness.
Thank you, Your Honor. We call Dr. Sarah Femer. Doctor, I will remind you that you're under oath.
Yes, sir.
Now, would you please introduce yourself to the jury?
I'm Dr. Sarah Femer. I'm a licensed orthopedic surgeon here in town. I treat injuries and diseases to the muscles, the tendons, and the joints. Most of the patients I see have had some sort of traumatic injury or incident. In this case, I've been called on to help Miss Payne with a problem in her neck area.
Now, doctor, please tell the jury about your first meeting with Patty Payne.
Well, she was referred to me by her family physician, whom she'd seen a few days after the accident. I saw Ms. Payne in my office on July 12th, which was a couple of weeks after the accident. Now, when I asked her about her history of her injury, she explained to me that she had been rear-ended while stopped at a red light at the intersection of Main and Avenue A.
And what is your diagnosis of Ms. Payne's current medical condition?
Ms. Payne has a herniated disc in her neck that is causing a nerve impingement with degenerative changes throughout the neck. In English, that means that because of the pain, she's not using her neck muscles like she used to. So she is slowly losing her strength there. And she's also suffering a general weakening of her bones and in the spinal column at the neck. It's a condition that requires surgery.
Are you familiar with the reasonable and necessary medical expenses in this county for the surgery that Ms. Payne needs and for the therapy and treatment that will be needed afterward?
Yes, I am. In my experience, such a surgery and follow-up treatment would cost about $35,000.
Do you believe that Ms. Payne will have any permanent impairment after the surgery?
Yes, I do. It may be more difficult for her to do certain things that she's used to doing. I understand that she's a waitress, and I believe that the surgery will leave her with limitations in that job, such as in her ability to lift heavy trays and so on. And she'll also be limited somewhat in her ability to move her neck.
Thank you, doctor. Your Honor, I have no further questions at this time, and I pass a witness.
Cross-examination.
Thank you, Your Honor. Dr. Feamer, you previously mentioned that you took Ms. Payne's history regarding the accident when she first visited you, right?
Yes, that's part of the standard procedure when I see a new patient. Basically, when a patient gives you a history, she informs the doctor how she was injured and about what kind of pain and what kind of problems she's experiencing on the day of the visit. Well, the history is significant for the doctor to use in diagnosing the cause of a patient's problem.
And when a patient tells you what happened to her, you pretty much have to take her word for it, don't you?
Yes, I suppose so. I presume that the patient has a good grasp on what's caused her pain.
And when Ms. Payne told you what she did for a living, what she did in her daily life, you took her word for that too, didn't you?
Well, we mostly talked about the accident, but I have a general idea about what a waitress does.
Doctor, you testified that there have been many degenerative changes in Ms. Payne's neck, a weakening of the muscles. Isn't that right?
Yes, that's what the X-rays and MRI suggest, yes. Now, actually, degenerative changes are best explained as an aging of the bone structure in the neck and in the spinal column in a person's body.
Would you agree with me that the degenerative changes are significant?
Yes, that's fair.
Now, is it your testimony, Doctor, that Ms. Payne's degenerative condition was caused by the accident in June?
No, I don't believe I've testified as to the cause of that condition, but I have seen the photographs of the accident, and I would say it's a good possibility that the collision caused Ms. Payne's injuries.
You mentioned, though, that as a waitress, Ms. Payne is required to lift heavy trays of food and drink.